Yes, Mr. Wolf.
Good morning, my lord. As you will have seen, definitely David, Peter Locksley and I appear on behalf of, I'm going to call them the claimant, which I think is probably right, Global Feedback.
Yes.
Rose Grogan, Mark Westman Smith and Colleen Ward appear on behalf of the two Secretaries of State.
Yes.
In terms of materials, you should, I hope, have two core bundles, two supplementary bundles, a legal material bundle, essential reading, list of issues, chronology, some skeletons, and possibly a replacement exhibit, which we're all going to try and ignore if we can.
I'm not quite sure what you're calling the replacement exhibit.
So some replacement pages were served by the
Yes.
defendant last week.
Yes.
Which,
I think we have got those.
we don't think you need them, but if you do, Ms. Ward will explain their provenance.
Right, we don't need to attend to that now.
Not for now, no. Lord, you will have seen, and indeed you will know from the history of this matter, that this is a substantive judicial review hearing pursuant to judicial review permission granted by this court in June in relation to the legality of the government's, or the making and adoption of the government's food strategy the previous June 2022. You've got that document at Core Bundle 163 and the court's permission order is at Core Bundle 2, page 64. I won't go to either of those for now. My Lord, in terms of timing, just in case the court wants an indication, I think I will be most of the morning. Ms. Ward thinks she won't be the rest of the afternoon, so I may get to replying today.
I see.
So we may finish today.
Yeah.
If not, I will be replying overnight and tomorrow morning.
Fine. All right, well, that's very clear. So we're not under pressure of time. That's good to know.
Don't think so.
But of course, you'll have an eye to the possibility of finishing today if that can properly be done without compressing anybody's argument.
Lord, yes.
So we'll see how we go.
Lord, yes.
Thank you.
You will have seen that the context for our submissions is the Climate Change Act of 2008.
Yeah.
And I'd like to start with that, if I may.
Yeah.
You have that in your legal materials bundle at tab 3, starting at page 35. Lord, what I propose to do for the moment is to deal with those bits that don't deal directly with the Committee on Climate Change and come back to the Committee on Climate Change later in my submission.
Right. Just to help you, and others too, you can assume that we've familiarised ourselves at least with the main statutory materials and the skeleton arguments, of course, and the factual background, not in immense depth, but it's in sufficient depth to understand how the arguments in the skeleton arguments are presented to us. If that helps you
it does.
Presenting
it does.
the
Lord, if I take things too slowly, you'll let me know.
Certainly.
Lord, within the Climate Change Act, just in terms of the overall structure of it, we have Section 1, the statutory target for climate change for 2050, relating to the UK net carbon account, which is required to be at least 100% lower than the 1980 baseline by 2050. That gives us the net zero.
Yes.
The 100% figure was substituted in 2019. You've got the statutory instrument that substituted that to give effect to the Paris Agreement.
Yes.
You then have, and indeed I've foreshadowed it, Section 2 and Section 3, provisions for the mechanics of amending that, the baseline year and or the target percentage, and that's what's happened. And within that, just as a note in passing, I said I wouldn't talk about the Committee on Climate Change, but there is a reference to taking account of the advice of the Committee on Climate Change in Section 3(1)(a).
Yeah.
You then have the framework of carbon budgeting. Again, we're not concerned with the detailed mechanics of this, and indeed Mr. Justice Holgate set this out in some detail in his helpful judgment in the net zero case, which I'm going to come to in due course, of course. We have in sections 4 and 5, and linked to them 8, they're all part of the framework of setting carbon budgets. So those are targets to be achieved during statutory periods leading up to the 2050 net zero, and they are, if you like, milestones on the way that have to be achieved on the way. So it's a nuanced regime that is intended to get the UK to net zero by 2050 in accordance with the Paris Agreement. And again, you have within that framework, not wishing to duck it, Section 7(1)(a), consultation with the, taking advice of the Committee on Climate Change, and likewise Section 9(1)(a), taking advice from the Committee on Climate Change. Importantly, in Section 10, I just want to pause for a second, if I may, on Section 10. You have that on page 40. Section 10(1), the following matters must be taken into account, and then there are two mirror provisions here, by the Secretary of State in coming to any decision under this part relating to carbon budgets. And those are quite important words because, as they express, they relate to any decision under this part. So the Section 10 framework applies, just to signpost where this is going, to the Section 13 process, which we'll come to shortly. So statutory factors to be taken into account by the Secretary of State across the board, including in relation to Section 13. And Section 10.2 gives a list of factors, technical and economic and other, around the setting of carbon budgets and around the implementation of carbon budgets, all put in place by the parliamentary framework. And then the parallel is 10.1b. Those same matters have to be taken into account by the Committee on Climate Change in considering its advice in relation to any such decision. So the Committee on Climate Change is expressly directed to consider those factors in relation to its advice on any decision under this part, and that would therefore include, we say, of course, Section 13 and indeed Section 14, not directly in play here, but you'll see how Mr. Justice Holgate picked those up when I go to his judgment in due course. So,
Mr. Wolfe, would it be fair to say that when Parliament intended the advice or views of the Climate Change Committee to be taken into account, it said so?
Well, it certainly did say so. It created some statutory processes around consultation with them. Our point is that they are not exhaustive of the occasions in which the Committee on Climate Change can either give advice or the Secretary of State needs to take the advice into account. Right. And you see that the first marker for that is Section 10.1. It's the Committee on Climate Change is taking a position and giving advice in relation to any exercise by the Secretary of State of a function related to carbon budgets under this part, and that catches Section 13. You'll see there's a bit more to it in due course. Just for completeness in terms of understanding the regime, one mostly talks about carbon, but Section 24, there are actually a range of targeted greenhouse gases, of which carbon dioxide is the one that around which the framework is built, but there are others, including methane, and as it happens, not an issue for the court to be concerned with. Methane is the greenhouse gas which is in play in the background of the concerns my client have here. You then have at Section 27, just by way of the definitions, the net UK carbon account. That's the phrase we've seen used in the net zero provisions and so on. And then 93, as I say, jumping over the provisions on climate change committees in a moment. Again, 93, meaning of greenhouse gas, and again, greenhouse gas means, amongst other things, CO2 and methane. And there's that's 92, 93 creates a regime whereby emissions in each of those is to be expressed in a carbon dioxide equivalent. So whilst the budgets and net zero are framed around CO2, behind that is a computation giving an equivalent figure for each of the other gases of concern. That then goes back, if I may, to the provisions which are critically in play here, or context in play here. Section 13, and they're not in play here, but important in relation to the net zero strategy decision we'll see in a moment. Section 13, and this of course is at the heart of the case before the court. The issue, and in one sense not the only, but certainly the critical issue, is whether Section 13 was in play in the process of making and adopting the food strategy. So I'll come back to more detail on this in due course, but just to introduce the propositions. The Secretary of State, and we'll come back to that because that's a contested question here, must prepare such proposals and policies. Just pausing for a second there, we'll see in the net zero decision how widely cast that can be, as the Secretary of State considers will enable the carbon budgets that have been set under this Act to be met. Just pausing for a second there. So this is undoubtedly one of the provisions to which Section 10 applies, which we saw a moment ago. And it's an obligation to prepare proposals and policies as the Secretary of State considers will enable. So there's a judgment to be made by the Secretary of State as to how those policies are to be framed, and also how they contribute to the overall position. And the overall position is picked up in 3, but before I get to 3, Section 13.2, the policies and proposals must be prepared with a view to meeting First of all, the target in section 1, and secondly, any target set under 5.1c, the other targets. So the policies and proposals are both in the context of getting us to net zero by 2050 and meeting carbon budgets along the way. And 13.3, the proposals and policies taken as a whole must be such as to contribute to sustainable development. The words taken as a whole are important because they recognise that there are certain circumstances in which you aggregate all your policies and proposals for the purposes of an evaluation. And that would be in 13.3, by reference to the concept of sustainable development, not in play here, but also generally in relation to 13.2 for the overall exercise of meeting the UK overarching statutory targets. But, crucially, underpinning all of that, the obligation is to prepare policies and proposals, not merely, as it were, to do the overarching exercise. It's to prepare the individual policies and proposals. And what we'll see when we look at the way Mr. Justice Holgate analysed this is that that's exactly the way he understood it in the net zero strategy decision, of course not appealed, and he identified various ways in which the Secretary of State, when formulating and considering those proposals and policies, needed to look at aspects of individual policies and proposals, and that's the important thing. It's not simply an exercise that's done at the economy-wide level, if you like. It's also done at the policy and proposal level. That's section 13. Linked to that, so section 13 is not time-specific. You'll see it's described elsewhere as a continuing duty, and that's important for the case before the court. And then section 14 is a snapshot obligation. As soon as is reasonably practicable after making an order setting the carbon budget for a budgetary period, the Secretary of State must lay before Parliament a report setting out proposals and policies for meeting the carbon budgets for the current and future budgetary periods up to and including that period. So there is a periodic reporting obligation to Parliament on the policies and proposals at that point. There's a snapshot report required, and that's what the net zero strategy document and framework was doing. But importantly, the section 13 obligation rolls on relentlessly in the background behind that process. So every now and then come to the surface and publish a report, but the evaluation, so the development and the evaluation of proposals and policies is an ongoing, continuing process. That's all I need for the moment from the Climate Change Act. I'll come back to the other provisions in due course. Just for the record, you also have page 81, tab 6, just to see the mechanics of that. The amendment order that changed the 80% to 100%. That is relevant. You'll see that in Mr. Justice Holgate's decision again, because what it meant was that carbon budgets 4 and 5, which are the near-term budgets, were set by reference to the 80% figure, and therefore were relatively undemanding, and indeed have been overshot. Carbon budget 6 was the first one to be set by reference to the 100%, the more demanding Paris Agreement net zero aspiration, and that's the one which the UK is struggling to meet, or struggling to put in place policies and proposals to meet. Again, that's set out in a little bit of detail in Mr. Justice Holgate's decision, but that gives you the timing of that. That's June of 2019, the amendment. And then you also have, in the same, in the next tab, you have the Carbon Budget Order 2021, which you see on page 85, set the Carbon Budget 6 figure, and that's the furthest away in time which has so far been set. You see that's set for the period 2033 to 2037. Yeah. So that is the overall position to which the section 13 and, insofar as relevant, section 14 exercises directed, but of course those exercises are themselves the composite of lots of small granular activities. Can I then pick up, if I may, put that bundle to the one side for the moment, pick up the other bundles, starting, if I may, in supplementary bundle 1, and just as a leading to looking at Mr. Justice Holgate's decision,
yes,
show the court the steps that led up to the making of the net zero strategy, which is fundamental to our case. So in SB1 at page 70, you have Materials, these are materials, just so the court understands the provenance of them, that were produced by the government, by the Secretary of State, sorry, in response to the net zero strategy claim. So these were documents that were before Mr. Justice Holgate, therefore been in the public domain since that point, as opposed to documents produced for the purposes of this hearing. First document, SB1, page 70. This is a copy of the ministerial submission that was produced on the 15th of October of 2021 to the then Secretary of State and the then Minister. As it happens, it was the Minister who signed off the net zero strategy, but at this point the Secretary of State was still involved. This was produced, giving them, a few days before the document was to be signed off, the background materials they needed for that purpose. And what we see is we see at the foot of page SB 170 the documents that they were provided with, which included draft of the net zero strategy, and then Annex C, something called Policies and Proposals Constituting the CB6 Delivery Plan. I'll show you that in a moment. And then you have, behind that, you have the actual ministerial submission, net zero strategy draft for publication. And then just to pick up, if I may, 4 paragraphs in this document. First of all, paragraph number 4, advice, as previously agreed with the Secretary of State, redaction, the net zero strategy will, C, act as our delivery plan for Carbon Budget 6 under the Climate Change Act 2008, setting out the policies and proposals that credibly enable CB6 and earlier CBs to be set. So, setting out the policies and proposals that credibly enable to be met. You'll see a bit of understanding maybe of what's meant by the words credibly enable in a second, but that is what's being provided and that's what's about to be adopted. Then at paragraph 8, we see the opening words of this, drawing from net zero scenarios, the net zero strategy presents a modelled indicative pathway broken down by sector. And then about halfway down that paragraph, second word in, if delivered in full, the specific policies and proposals outlined in Annex C are projected to overachieve CB4 and CB5, just pausing for a second there. Those are the ones that were set by reference to the lower target, so overachieving them is good but not to be celebrated too much. We need to overachieve on CB4 and CB5 in order to stay on track for our NDC and CB6, it's CB6 with which we're concerned here, which were set after we increased our ambition to meet net zero by 2050. But stay on track are important words. They are also projected to achieve our 2030 nationally defined contribution. The strategy provides a strong foundation for decarbonising in the 2030s, with the stated policies and proposals projected to directly deliver, important words, 95% of the emissions required for CB6. What we'll see in a moment is that the directly delivering policies set out in Annex C delivered, but only delivered, or projected to deliver, but only projected to deliver 95%. So there's a gap, there's a shortfall. Then we have a table which Mr. Justice Holgate spent a long time trying to understand and never got a satisfactory explanation of. And then paragraph 10, although our ambitious SR bid for NZS policies did not result in all the funding requested, we advise that the net zero strategy package of policies and proposals credibly enables us to be on track for all our legislative carbon budgets and therefore fulfills our duties under sections 13 and 14 of the CCA. Really important sentence. This is based on current modelling and planned policy work to identify further options over the coming years to deliver CB6 in full. Really important words. Taking advantage of technical and logical process, innovation and societal trends. It is not necessary the policies and proposals included on the face of the net zero strategy to deliver 100% of the emission reductions required for CB6, providing they are sufficient to keep the targets in reach and that we continue to develop further policies and proposals as required in the coming years. So this was a contested issue in the case before Mr. Justice Holgate, because the claimants there said it wasn't lawful to only quantify 95%, the Secretary of State needed to quantify 100%. Mr. Justice Holgate disagreed, said it was lawful to only quantify 95%, but then explained what happened in relation to the other 5%. And it's in the other 5% territory which we find ourselves here. So the important thing that I draw from that paragraph is the planned policy work to identify further options and the continue to develop further policies and proposals as required in coming years. And we say that the food strategy, which you'll see in few minutes' time, is exactly an example of that activity, and therefore falls foursquare within this description and the Section 13 framework process that's been described. That then is the ministerial submission. The Secretary of State and the Minister were provided with a draft of the net zero strategy. You've got a copy of it. It's complicated because it's got lots of colour tracking and so on it. I don't think we need to look at the detail of it because it's materially the same as the final one for our purposes. There was then another ministerial submission. You have this at page 338. I don't think we need the detail of it, which gave the ministerial sign-off. That was the 18th of October. That was Minister Hand's. And then at SB 1339, we then have the published, 19th of October, published net zero strategy. Or rather, we have an extract from it, I should say. Within it, the chapter we have an extract from is chapter 3. This starts on SB 1343. Chapter 3, reducing emissions across the economy. And then there's a subsection 3.6, natural resources. Within that, you have a heading on 344, just to introduce the terminology. On 344 above paragraph 3, you have, the heading is agriculture, forestry and other land use, AFOLU. And then at 351, so that's the introduction to the chapter 3 sub 6. 351, you have the heading then, policies and proposals. So this is telling the reader, which is the Parliament to whom this section 14 as a report is addressed, that what comes in these paragraphs are the policies and proposals identified by the Secretary of State under section 14, coming out of the section 13 exercise so far. So the first, again, the heading, AFOLU, the court's now familiar with that. And within AFOLU, on page 352, above paragraph 28, is the subheading, agriculture. And then within that, really important paragraph, this is the description of the food strategy and the net zero strategy. And the reader is told, under the heading policies and proposals, the government's upcoming food strategy will support the delivery of net zero, amongst other things. And then line 5, really important words, government is exploring options to reduce carbon emissions from food production, support innovation in the food sector, incentivise land use changes, sequester more carbon to preserve natural resources. So will support the delivery of net zero, government is exploring options. Those are both things that are said of the upcoming food strategy. We then have page 365, if you would, in the same bundle, the witness statement of Sarah James. So this was a witness statement provided for the net zero strategy litigation, which exhibited the document, the ministerial submission that we've just seen. At page 407, she refers to some of the materials we've just looked at. The following, as paragraph 132, the following annexes were provided to the Minister in addition to the main advice. And over the page 408, top of the page is Annex C. And she says this, Annex C, a list of proposals and policies that deliver direct emissions savings towards our carbon budgets and NDC. That's effectively the quantified ones. Direct emission savings, the direct word is an important word in that sentence. And then there's a footnote, footnote 14. We come to the bottom of the page, and it's a slightly hard to understand footnote, but I think we will understand what it means in the end. See paragraph 132C. For a finalised list of NZS proposals and policies exhibited to this statement, SJ13. We'll come to that in a second. So what she's telling us is that the SJ13 is not what went to the Minister, it's a finalised list, and as you'll see in a moment, it came after the net zero strategy was published. The list provided in Annex C, what was given to the Minister, was in effect a very advanced but still working draft, as at 15th of October, of policies and proposals in the net zero, which delivered direct emission savings towards our carbon budgets and NDC, together with some key enabling measures judged essential to support those deliver direct emission savings. The list referenced in 132 is a final version, I think that must mean SJ13, which is based on work done to align the quantitative analysis and the text describing proposals policies as they were described in the published NZS on 19th of October. Slightly complicated to understand sentence, but where we end up is Annex C was the direct, the quantified. That was the stuff that was before the Minister. No criticism, we're not making a criticism about any of this, it's just to understand what the documents say. Whereas SJ13 is a document produced later, which, as you'll see in a moment, picks up all of the policies and proposals from the food strategy, from the net zero strategy. That's footnote 14. You then have, paragraph 160 and 161. The same thing is described. I'm slightly clearer at this point. Above the heading on page 416, we then have confirmation of projected emission reductions from net zero strategy proposals and policies following formal conclusion of the 2021 spending review. And then 161, separately to assist with the ongoing policy development and delivery process to meet our legislated carbon budgets and our NDC, my team and NZS analysts compiled two lists after the NZS was published, which I exhibit here. A final list of all the quantified and unquantified proposals and policies in the NZS, which includes the state of their quantification or not at the time of the publication. So this then, I hope, is consistent with what I've said a moment ago. SJ13 is the total list, quantified and unquantified, whereas Annex C is only a subset of that. No complaints made about that, but that's just to explain the documents. You then have, back to 296, 296 is the beginning of the document. Sorry, it's not 296.
Yes, it is. Just SJ13.
I'm sorry.
SJ13.
My lord, yes.
Yeah, that's page 296.
296 is the beginning of it. That's the heading of it. SJ13, list of proposals and policies for net zero strategy. Chapter 3, proposals and policies. Then we see the headings. Chapter, proposal or policy, quantification status. So very clearly tracking, as you'll see from the headings down the left-hand side, the paragraphs in the food strategy, in the net zero strategy, and quantification status is given. And within that we go to 315, internal page 20. And the last but one entry on the page, 3.6 natural resources, you've seen that chapter. Agriculture, the government's upcoming food strategy will support the delivery of net zero, nature recovery and biodiversity commitments and will help to create a food system that incentivises farmers to produce high quality, high welfare food in the most sustainable way. So that is part of the text, and we don't complain about the fact that it's part of the text, but it's only part of the text from the net zero strategy quote in relation to food strategy, because it omits the other important element of we will develop policies. It's merely describing the net zero strategy rather than talking about the we will develop policies. But that is then identified as an unquantified policy or proposal within the net zero strategy context. No complaints made of any of that. We then, if I can put that bundle to one side, return to the legal materials bundle. We then have the net zero strategy decision, Mr. Justice Holgate. You have this in tab 21, paragraph 601, page 601. Sorry. So this was a challenge to the legality of the Section 13 exercise and the Section 14 report. Paragraphs 5 to 15 helpfully summarise the carbon budgets process and put some numbers on all of that. Making the point at paragraph 12, page 607, last two lines, it's common ground that the target in CB6 is substantially more challenging than those previously set. That's the one that we're struggling with. Then at paragraphs 28 through to 49, I won't take you through those. That's Mr. Justice Holgate summarising and to some extent quoting from the provisions that I've shown the court directly. Paragraphs 50 through 55 I'll come back to in due course. They deal with the committee on climate change. And then the guts of the materials we need here start at page 637 of your bundle. The heading is Ground 1.1, the duty in section 13.1 of the Climate Change Act 2008. 161 and 162 set out the claimant's complaints before that court. 163, important analysis here. There are a number of points of interpretation of section 13 which have become common ground between the parties. Firstly, the obligation on the Secretary of State under section 13 is a continuing one, the point I mentioned before. Secondly, his duty is to, italicise, prepare measures that will enable the carbon budgets to set. The statutory scheme recognises that proposals will evolve over time and will be introduced and developed at different stages. So the policies and proposals in the section 13 exercise will evolve over time and be introduced and developed at different stages. We say that's exactly what this court is faced with here in relation to the food strategy. Policies may need to be reconsidered, etc. 166. Thirdly, it agrees that the phrase policy and proposal is deliberately broad. And then towards the foot of that, Mr. Wolfe and Mr. Jason Coppell QC also accepted that the phrase proposals and policies includes an emerging policy or a proposal to be further developed. So that's claimants accepting the Secretary of State's case that the policies and proposals for section 13 purposes and therefore the section 14 report could include emerging or yet to be further developed policies. That was in defence from the Secretary of State of the inclusion of a set of policies precisely like the food strategy, which were to come later and which were to fill the gaps in above the 95%. And that was what Mr. Justice Holgate held to be lawful, and the claimants lost on that 100% point. Over the page, fifthly, Mr. Honey submitted doesn't require certainty. There's the word will, so there's an evaluative question involved in that. We're not directly concerned with that. There's then a debate in 171 to 172, looking at the first of the factors which Mr. Justice Holgate held to be, in effect, mandatory material considerations, obviously material matters, for the Secretary of State or the Minister to be appraised of in the section 13 and section 14 exercise. 171 and 172, he rejected my arguments to the effect that you got that from the concept of sustainable development. Then he said this in 173. Nonetheless, in my judgment, there are two more straightforward routes by which section 13.1 requires the Secretary of State to assess the timescales over which his policies and proposed policies are expected to take effect. First, this must be an obviously material consideration in predicting whether those measures will enable carbon budgets to be met, applying the test below. Second, section 14 implies the point will already have been addressed when the policies covered by the section 14 report are prepared under section 13. So we're concerned with the section 13 bit, but an obviously material consideration for the decision maker in relation to a policy which falls within section 13 is timescale. When is it going to deliver whatever it's going to deliver? Then there's consideration by the judge 174, 175, 176 of this question of whether the quantified policies needed to reach 100%, which was the claimant's case. Judge rejected that, 177. I conclude there is no basis in the statutory scheme to justify the court holding that the obligation in section 13.1 requires the Secretary of State to be satisfied by quantitative analysis that measures with quantifiable effects will enable at least 100% of the emissions reductions required by the carbon budgets to be achieved. It was permissible to only be quantifying 95% and have other policies and proposals in play that would get you to the 100%. And that was the basis on which Mr. Justice Holgate decided that point, and that matters here because we, as I say, we are within that 5% of how you're going to achieve what you otherwise were not planning to achieve. 185, page 640. As the claimants have said, section 1.1 and the carbon budget set numerical targets. the Secretary of State accepts that there must be some quantitative assessment of the effects of the proposed policies. If those quantified effects fall significantly below meeting the whole of the emissions reduction required, then the Secretary of State would need to be satisfied that the meeting of that shortfall by the qualitative analysis is demonstrated to him with sufficient cogency. As the shortfall increases, so that task will be likely to become increasingly challenging for the Secretary of State and his officials. Proposition we get to is that the Secretary of State needs to properly understand how the unquantified policies and the planned policies and proposals are going to help meet the shortfall in order to allow for him to have had a lawful approach as at the net zero strategy point. In 187, as I explained below, the briefing given to the Secretary of State when approving a package of policies for the purpose of the Section 14 report and the report itself must address A, the assessment made by officials of the quantitative contributions individual policies and proposals expected to make, B, the justification for relying on unquantified policies to make up any predicted shortfall. These requirements enable the scrutiny, firstly by the Secretary of State of the policy package, and secondly by Parliament, the CCC, and others of the Section 14 report. So that's important in terms of explaining to Parliament and the public how it is we've got to this point. We've got 95% quantified, the remainder is to be dealt with in this way. Then there's a reference 188 to the CCC's annual reporting process and the importance of the regime around that. I'm not going to pause on that just for the moment. Then 190, it is through these mechanisms, that's including the statutory reporting process, that the merits, realism and efficacy of the Secretary of State's climate change policies can be probed and evaluated, so that he may consider, for example, whether any additional work needs to be undertaken, amendments made, or new measures taken pursuant to his continuing obligation under Section 13.1. So not only have we got food strategy being identified as one of the policies and proposals, there's also part of the Section 13 obligation, this almost freestanding consideration of an evaluation by the Secretary of State of what more work needs to be done to get to that place. 194, if I may. We then get to the legal sufficiency of the briefing provided to the Minister at that point. 195, under that heading. The second component of Section 13.1 is the Secretary of State's obligation to be satisfied that his proposals and policies will enable carbon budgets to be met. As I've explained above, this depends on the making of predictive assessments by the Minister. The nature and extent of the work to be carried out is a matter of judgment for the Secretary of State. Officials, of course, subject to satisfying the requirements of the legislation. So there's the predictive assessment element to all of this. Then there is the complaint, 196, of what was omitted. And 197, according to the claimants, those omissions were lack of assessment of timescales, failure to identify the quantitative analysis, failure to identify under the qualitative analysis which proposals and policies would meet the 5% shortfall. That was the complaint. Mr. Justice Holgate then says at 202, the statutory context is of paramount importance. It picks up a couple of initial aspects of that. I just want to jump in further down, if I may. 202 sub 5. Under the CCA 2008, the preparation of policies, proposals and policies under Section 13 is critical to achieving those targets. That directly links the process of the preparation to the criticality of achieving the targets. Then little Roman 9, although a quantitative assessment does not have to show that the quantifiable policies can deliver the whole of the emissions reductions required by the targets, any qualitative judgment or assessment to address the shortfall will have to demonstrate to the Secretary of State how the quantitative targets can be met. Then in 10, carbon budgets relate to the whole of the UK economy. Achievement of those targets requires a multiplicity of policy measures falling within Section 10.2. So as I said when we looked at Section 13, although Section 13 overall is directed at the economy-wide evaluation, that requires what the judge called a multiplicity of policy measures addressing underlying things. Those measures will be operative at different points in time. Some will apply in isolation and others in combination. Whether the overall strategy will enable the statutory targets to be met depends on the contribution which each policy or interrelated groups of policies is predicted to make to the cumulative achievement of those targets. That is why we are not simply concerned, indeed it would be bizarre if we were only concerned with the overarching yes-no question. The Section 14 report, the Section 13 process, the public and the CCC are concerned with the elements that get you to that point. And that's why Mr. Justice Holgate was concerned, as we'll see in a second, to ensure that the evaluation of the individual policies and proposals was properly done by the Secretary of State. the merits of individual measures, their contribution to their deliverability, together with the deliverability of the reductions in GHG emissions required by Section 1.1 and 4.1, are all essential considerations for the Secretary of State or the Minister in his place. Then 204, in my judgment, one obviously material consideration which the Secretary of State must take into account is risk to delivery of individual policy proposals and the achievement of carbon budgets and the net zero target, necessarily implicit in the statutory scheme. This must in turn depend on relative contributions made by individual measures to achieving those targets. At 211, viewed in the context of the statutory scheme, I have no doubt that the quantification of the effect of individual policies was an obviously material consideration on which, as a matter of law, information had to be provided to the Minister so that he could discharge his function under Section 13 lawfully. The defendant's role in approving a package of policies so as to enable the statutory targets to be met is critical to the operation of CCA 2008. Risk the delivery of individual policies and proposals is obviously material. Then 212. My general interpretation of the statutory scheme applies all the more so to the circumstance of the net zero strategy, that's the Section 14 bit. The Minister was told in para 8 of the submission that the assessment was based on the assumption that quantified proposals and policies would be, quotes, delivered in full. You've seen that. As we've seen, the net zero strategy described the scenarios and the delivery pathways as highly ambitious, referred to considerable delivery challenges. It was in this context the officials projected the UK would overachieve CB4, CB5, but would only achieve 95% of the emissions reductions required by CB6. Ultimately, the Minister's decision depended on unquantified measures and other quantified measures to be developed further. That was critical to the legality of his decision. Then 216, there remains the manner in which the 5% shortfall was handled in the ministerial submission. Although this was critical to the advice given that the proposals and policies would enable CB6, the Minister was not told various things. In 217, having regard to the statutory scheme summarised above, I've reached the firm conclusion the four matters set out in paragraph 216 were also obviously material. Just pausing for a second, what we say, it's not in dispute in the case, but just so the court understands this, is that all of these various things which were identified as obviously material at this point in Section 13 terms would be, again, obviously material at the point of adopting the food strategy, if Section 13 is engaged, which we say it is. But there's no case against us about the engagement of Section 13. The Secretary of States are very clear in saying they make no positive case about what Section 13 would have required, and they don't argue compliance with it. So the only question, we're not concerned about the content of the Section 13 duty at the food strategy point. We're merely, these proceedings, concerned about the engagement of it. So I'm just signposting where that would take you if one were looking at that question. Para 222, please, I'm nearly done. As I've said, the obligation under Section 13 is a continuing one. It's not necessary to recall that the argument in this case has focused solely on whether the defendant complied with his duty under Section 13 at a particular point in time, October 2021, which is directly connected to the discharge's obligation at the same time to present a report under Section 14, the NZS. His Section 13 decision had to include measures to address CB6. The announcement to Parliament and the public of the defendant's performance policies was plainly one of the key stages in the operation of CCA 2008. The party submissions did not address any implications of the issues I've had to resolve for compliance with Section 13 duty on a continuing basis, nor was there any evidence on that aspect. Accordingly, my reasoning and conclusions on, for example, legal adequacy of the material before the Minister on qualification should not be treated as necessarily applying to compliance with Section 13 at any point in time. So the content question, both the trigger question and the content question were left open by the judge. This court is concerned with the trigger question, but again, not concerned with the content question because no case is made on that.
Speaking for myself, I'm having difficulty in understanding this conceptually. Why is the obligation in Section 13 a continuing one? It seems as if his analysis all seems to be at a particular point in time when they make the Section 14 report.
So he's analysing it by reference to that point because that's the point at which it's crystallised.
Right. So why is he going on to say something apparently obiter that isn't before him?
I don't know why he's gone to say, other than I suppose, I showed you much earlier on in the judgment, the agreement between the parties that it was a continuing duty, because it's a duty in a sense. It's a duty that applies in between the spot reports.
I don't understand that, I'm afraid. It's my fault, Mr. Wolf. I need your help on this. If the judge is saying, and nobody seems to be challenging this, at least as I understand it, that it's a lawful discharge of the Section 13 duty that you don't have 100% quantified policies. So it was 95%, 5% were left unquantified. He's saying there's nothing unlawful, that is a lawful discharge of the Section 13 duty at that point in time. Then why isn't that the end of it? Why is the Section 13 duty then a continuing one? What does that mean?
Well, I think what it means, I don't know what the judge meant by it, or let's sort of start, as it were, stepping back. It's a lawful discharge to have a package of policies and proposals in place that are not all quantified to 100%. That was the 95% point. It's lawful to have making up some shortfall, and the judge didn't specify how far you could take this, some shortfall by effectively signposting, my word, future work to be done, including the development and evolution of future policies and proposals, and therefore the Section 13 exercise at any point in time could be satisfied by a mixture of things, some of which were quantified, we'll do this on this timescale, it will have this effect, some of which were, we will, for example, develop a food strategy. So that's a lawful discharge of the Section 13 obligation. But the important point about the Section 13 obligation is it doesn't only pop up at the Section 14 point. It doesn't only arise that you do nothing for several years and then you suddenly produce a Section 14 report. Indeed, if that were the position, you wouldn't need Section 13. You would simply have Section 14 every 4 years, publish your policies and proposals. The point about Section 13, and this may be what the judge meant by continuing duty, is that it exists throughout that period, and it's saying to government, you have to be working on this on a continuing basis. Every now and then you produce a report, a snapshot, but this is not the kind of exercise where you do nothing for X years minus 6 months and then pop up and suddenly produce a report. If that were the kind of exercise, you wouldn't need Section 13, you'd simply have Section 14. Every so often, produce a report telling us what your snapshot position is. And I think that's what's meant by continuing duty. It subsists and creates an obligation on Secretary of State in between times, and that's what matters. And I like the judge, I don't propose to make submissions in any way exhaustively on how and when that would bite. And indeed, there have been arguments at earlier stages of this case about the suggestion being made the claimant was overreaching, if you like, saying Section 13 applied too widely. That's not our case. Our case is very specifically focused on the food strategy and the circumstances and way in which and framing around which it came to be pushed down the track, in my words.
That's very helpful. That certainly helps me to understand how you put the case and what the judge was getting at. I do understand that, but I'm afraid it still leaves me, in my mind, uncertain how a court would then ever decide whether the continuing duty has been breached, because you're only ever going to ask the question whether it's been breached at a particular point in time.
Yes.
And if it's a continuing duty, how are you going to say it's been breached?
Well, again, I don't seek to answer that question exhaustively. I seek to only answer it in relation to the particular circumstances that we have here.
Yes.
Which is the way in which the food strategy was positioned within the net zero strategy, which I've shown you. So that was identifying a future process that would lead to a future trigger point, or not trigger point, it's the wrong word, a future decision and a publication and a point in time. So we're not asking, and I'm not making submissions about how you would judge breach at points along the way to that, or how you would judge breach in relation to things that were simply meandering along towards the next Section 14 report. Our submissions are entirely focused on the food strategy. I mean, as it happens, there are other policies that were dealt with in a similar way, but they're not before the court. How this was dealt with in relation to food strategy, which was specifically identified as developing future policies to help meet the shortfall, and was going to culminate in a point in time, and did culminate at a point in time. So that's the point at which the court tests the Section 13 obligation. It's the process leading up to, and in this case, the production of the food strategy report. Again, not seeking to identify other circumstances where that might apply, and I completely see my Lord's conceptual concerns about that, because to some extent some of these activities will be going on in the background. But at the point where this comes to the fore and something is produced, which is, in this instance, directly a manifestation of something flowing from the Section 14 report, we say that's an easy case. There may be harder cases, but they're not before the court. So I'm not sure I can...
Just to follow, if I may, I don't want to cut across, but just following up on that. If it is the process, as you say, leading up to the production of the food strategy, that means that for the purposes of identifying a breach of a continuing duty, you have to look at a particular strand of activity, or you can look at a particular strand of activity and say that that is a contributing activity to the Section 31 duty being discharged, and you're entitled to scrutinise that and see whether it is consistent or not with the obligations of the Secretary of State or the government under the Climate Change Act.
My Lord, yes. Although again, we don't. I mean, partly because we don't need to, but I can see it's a more difficult question. We don't say, right, well, at week 3 where were they? At week 4 where were they? At week 5 were they? Because they're allowed to do their homework. They're allowed to do their workings out, obviously. And in the course of workings out, all sorts of things will happen. But at the point where you come to the fore and you say, right, this is the food strategy, and the food strategy is not just any old thing. It was specifically signposted. Sorry to keep repeating that point, but it's fundamental.
So when the food strategy crystallises as a strategy, one is entitled then to look at it and invite the court to review it within the frame of Section 13. Is that the point?
Yes. And as I said, the way the issues work in this case is that neither party is actually, ironically, asking the court to do that exercise, because the Secretary of State doesn't advance a positive case on what Section 13 would have required at that point, simply says it wasn't engaged. So ironically, the court isn't even being asked to do that. The court's merely being asked the question of were the Section 13 obligations engaged at that stage. If we needed to, but we don't because of the way it's worked out, we would refer back to some of the things that Mr. Justice Holgate said around quantification, delivery risk, timescales, but we don't need to because the way the case is framed. The simple point is that they internally, if you like, weren't purporting to discharge the Section 13, and they don't now want to be held to account for not discharging it. In one sense, I mean, the timing is sort of odd, because not odd. The timing is fortunate or unfortunate, depending which way you look at it. Which is that the food strategy came out at about the same time Mr. Justice Holgate was handing down his judgment.
Yes, he handed down his judgment on the 18th of July.
A week or two afterwards, exactly. So in one sense, what they're saying is we didn't have the benefit of foresight. Well, they can perhaps be forgiven for that. They were carrying on to some extent with the understanding that had informed the net zero strategy process previously. They carried on using that understanding, which turned out to be, we say, a wrong understanding, but you don't need to test that. You simply need to say, was the obligation still being carried along? That's 222. Just a couple more. There's a couple of paragraphs really more focused on the Section 14 report, but the paragraphs around 242 and into 243 and then 247 are around the transparency which comes from a Section 14 report, and that really is to some extent picking up the points we've just been canvassing around. We don't say a Section 14 report is analogous to food strategy or vice versa, but the food strategy comes out of the Section 14 report and is a further manifestation of the transparency exercise, and is in any event the point at which we say we're entitled to test the point. So, my lady, my lords, in one sense, our case on Section 13 application, and it's actually a key driver for the whole case, is very simple, and it's essentially what I've been saying so far, which is that whatever else may be the situation with Section 13, if, as here, you have a policy, the food strategy, which is so clearly identified within the net zero strategy on the face of the public Section 14 report as being a future policy or proposal that will be evolved, the net zero strategy itself says that. That is reinforced by the ministerial submission, which talked about further future policies and proposals being evolved, all of which is to meet the shortfall, and was identified then before the course of the net zero strategy case, SJ13, you've seen already, as being one of those policies and proposals that would have that effect. And we say, unless one says Section 13 effectively is a dead letter in between the Section 14 reports, and I'm not sure anybody says that, but certainly not our case, if it has any life at all between the Section 14 reports, this is an instance, and there may be others, and I'm not seeking to exhaustively define, in which Section 13 was engaged, in the process of, oh, we're not so concerned about that, and in then the publication, adoption and publication of the food strategy as a report. And we get that from the statutory framework, we get that from the way in which the net zero strategy itself positioned the whole thing, and we get that from the way in which Justice Holgate analysed the obligations around the unquantified 5% shortfall. The food strategy itself, look briefly at it, we're concerned only really in one sense in passing with what's in it. You have the food strategy in core bundle 1 at page 163.
Yes.
My clients, of course, at a merits level are concerned about what's not in it, but that's not an issue for the court. You have the Secretary of State's forward, you then have an executive summary. I just want to post some bits from the executive summary, if I may. Page 170, paragraphs 8, 9, 10. Paragraph 8, this strategy will help ensure we deliver on this government's ambition for a prosperous agri-food sector and that healthier and more sustainable diets can be achieved by all. Food strategy. Paragraph 9, our objectives for this strategy are to deliver, and then there are 3 objectives. I say that because we'll return to the 3 objectives in a minute. Our objectives for this strategy are to deliver, and then bullet 2, second objective, a sustainable, nature-positive, affordable food system, etc. To achieve these objectives, that's paragraph 10, we will, and then there's a series of bullet points, the 4th of which, facing page 171, is reduce greenhouse gas emissions and the environmental impacts of the food system. And then over the page, 172, heading is summary of key measures. The key new measures and proposals in this strategy to deliver against our objectives are below. And then they go through objective 1, 2, and 3, and that's tracking the bullet points within paragraph 9 that we saw a moment ago. And with objective 2, I alighted on, quote at the top of 173, deliver a sustainable, nature-positive, etc. food system. And then second bullet is dealing with matters related to net zero. So my point simply is this, considerations in the food strategy quite properly and quite necessarily, consistently with what was said before about its signposting in relation to the food system, agriculture and net zero climate change commitments. This is not simply about, let's say, healthy diets or whatever else it may be. It also includes measures in relation to that. And that, of course, is entirely consistent with the way it was signposted and set up in the earlier process. But nothing turns particularly on any of those specific details. We then say, and in one sense that's the beginning, middle and end of it, that in the light of those matters, this was a policy left over from the Section 13, Section 14 exercise, to which Section 13 then applied, and we're not concerned with the content of the Section 13 duty. It's always a tempting mistake, I suspect, and I'm about to make that mistake, to look at the other side's case and respond to it in anticipation, but I'm going to do that a little bit just to signpost matters so the court knows where we're going on this. The defendants, obviously there are 2 of them, the defendants' primary response on all of this in our submission comes from a series of impermissible opinions from officials. The opinions in question, these are all in the supplementary bundle. Page SB 1551 first off.
So
Sorry, I don't mean impermissible opinions.
Page?
551, I'm sorry, Lord. I mean inadmissible in these proceedings. They can hold whatever opinions they like.
Yes.
Yes, I think we understood. Yes, you meant inadmissible.
Inadmissible rather than impermissible.
Yeah.
551, I'm just going to pick on the first of them and give you the references for the others. They all follow the same process. 551, paragraph 59. Paragraph 33 of the net zero strategy, which I took you to, is quoted at the bottom of page 550. And then on paragraph 59, this statement reflected the array of proposed and policies in the food system that have been considered and put forward by DEFRA Bayes as Section 13 proposals. These policies and proposals are included in DEFRA's contribution to carbon budgets, but in my understanding, the NZS does not set up the food strategy itself as a proposal or policy in its own right. And you have at least three other instances of similar statements being made by the officials in relation to the two departments involved here. They're entitled to that opinion. We say that's inadmissible. We refer you, or at least it's certainly going to answer the case, we refer you to the United Trade Action Group case, if I may. You have that in the legal materials bundle at tab 20, page 566. Beginning of the judgment. The page I need is at page 597.
Yes.
The law governing the admissibility of ex post facto evidence in proceedings for judicial review is already mature. Ample body of authority to demonstrate the correct approach. Without seeming to be exhaustive, we can identify 7 points in the light of the relevant cases. And then paragraph 1, or the second part, paragraph 1, deals with the professional views of, put there as officers, involved or not, who are seeking to elucidate and add materials. And it says this: the court must avoid being influenced by evidence that's emerged after the event, possibly when proceedings have been foreshadows or issued, so the need for caution is plain. And part of the context for that is 125 sub 4. Some elucidatory evidence will be appropriate and necessary, sometimes not. But even where the evidence in question is merely explanatory, the court will have to ask itself whether it will be legitimate to admit the explanation given. Circumstances will vary. For example, as was emphasised in Lord Justice Singh, with whom Andrews and Nugent agreed, when the court is dealing with a challenge to a planning inspector's decision, it will have in mind that there is an express statutory duty for a planning inspector to give reasons for his decision, etc. And we say we're in an analogous situation here in relation to the net zero strategy documents, because they are section 14, they're not reasons, but they're section 14 statements of your position to Parliament and the public. And so anything in the witness statements which seeks to go behind the court's understanding of those public documents, we say, is inadmissible, or certainly should be given the lowest of weight. So that's, if you like, part of my response, category 1, if you like. Category 2, can I ask the court to pick up the defendant's skeleton, if you would?
Are we putting...
yes, you can put United Trade Action away, thank you.
That away, yes. Sorry, and we're going...
defendant's skeleton, if I may.
Thank you.
Just really to pick up their misunderstanding about our case. Paragraph 8 on page 3 of the defendant's skeleton says this: the real issue for the court's consideration is whether section 13 of the 2008 Act applied to the food strategy. We agree with that. That turns on analysis of the relevant statutory scheme. We agree with that. And consideration of whether the net zero strategy was premised on, or whether it's, quotes, left over, any unquantified proposal for dietary change to form part of the FS, because that's the basis on which feedback argues that section 13 was engaged. And then it gives references. Now, I can't make those references work, but just to put everybody out of our misery, that is not our case. You have not heard me mention leftover policies on dietary change in my submissions about section 13. And nor is our statement of facts and grounds or our permission to appeal skeleton to this court premised on that basis. The defendant spends a lot of, airtime, paper time, both in terms of documents and witness statements, tracking the evolution of policies around dietary change. That evolution is not part of our case. Our case is concerned with, in one sense, what was in the food strategy as adopted, not what wasn't in the food strategy, but more importantly, how the food strategy as a process and as a publication which in due course matured was positioned and then flowed through in the process.
Mr. Wolfe, can I ask you this? In the defendant's skeleton, paragraph 8, if we left out the words for dietary change, does that otherwise accurately state your case?
Let me just read it again, sorry. And as a relevant strategy scheme, in consideration of whether the net zero strategy was premised on or left over any unquantified proposal to form part of the FS.
Yeah.
It's a slightly clunky way of putting it, but I think that's consistent with what I said.
Yeah. That's what I had
It's
understood.
a slightly narrowly worded version of it, but yes.
Yeah. That's what I had understood your case to be.
Yes. And it doesn't depend, and I've been very careful in what I've said in the first hour, not to mention dietary change.
No, absolutely.
Because it's not part of our case.
That's why I asked whether we simply...
Exactly. It's my client's background concern, as the court well understands, and we get to it not incidentally, we get to it in relation to the Climate Change Committee. A huge amount of material put in witness statements and so on. We said, well, if that material's in, we need to see the background documents. Lady just Andrews said, no, don't need that. In a sense, we perversely agree. I shouldn't say that, should I really? We perversely agree. But if it's in there, well, our proposition was if it's in there, we need it properly. But we say it just doesn't arise. It just doesn't arise. It's not part of our case. It's not part of the response to our case. So 9 then says, as the factual question the court has to resolve, and set out in the evidence provided by the Secretary of State, SSF EFR has ruled out dietary change. Well, we think that's actually wrong, but it doesn't matter. Our case doesn't depend upon it. So we are not concerned with the to and fro and all of that. And likewise, paragraph 10 similarly elaborates on the same point. Can I just pick up one sentence again, repeating the exercise I just went through with my Lord Justice Singh? Line 6 in that, the role of the FS was acknowledged in the NZS because it would support the delivery of net zero and because some other policies in the FS are relied on in the NZS. But there was no expectation it would be necessary to include additional proposable policies in the FS in order to meet CBs. Just pausing for a second there. If it matters, we would reject that characterisation, go back to the body of the text of the net zero strategy. It specifically said, we will develop further policies. So again, whatever the department's private thinking might have been, the published net zero strategy was very clear in saying, A, this will contribute to climate change, and B, we will develop further policies and proposals as part of the food strategy.
Well, that may be right, but if at that point in time, in publishing the net zero strategy, they have lawfully discharged the Section 13 duty because, so Mr. Justice Holgate has held, they don't have to have 100% quantified policies at that point in time. At the moment, I'm not seeing why then necessarily as a matter of law, the Section 13 duty applies to the leftover policy.
Let's sort of start from one step back. If the Section 13 duty only applies at the points of Section 14 reports, then obviously the claimant loses. We say it doesn't only apply at that point, it applies in between times, because apart from anything else, it's telling the government that you don't just wake up every few years and produce a report. And indeed, if you did, you would only need a Section 14 duty. So Section 13 duty is engaged in the background, and it's describing the activity that needs to take place. What we say, and I'm sorry if this sounds slightly repetitious, is that it is then engaged in this context precisely because the way the food strategy was set up. It was set up as a leftover policy. I'm not sure who coined that expression.
It's my fault, Mr. Wolf. I may have inappropriately introduced that phrase. If we go back to paragraph 33 of the net zero strategy, just remind me, if you would, where I find that.
Page 353 of the supplementary bundle.
353, yeah.
That's very helpful. Let's get that. Yeah, you see, could it be said that that's simply identifying, as a matter of fact, that at this point in time, this is our view, that the upcoming food strategy will support the delivery of net zero, etc., etc. In other words, what they're doing is not saying that we're going to apply the Section 13 process to the development of the food strategy, but that when we're doing the NZS in October 2021, we take the view that the food strategy will support what we've said in this document. Why is it?
Well, they're definitely saying that at that point.
Yes.
They're definitely saying that at that point, and that's part of their Section 13 process.
Yeah.
And importantly, one doesn't read. One looks at the content of paragraph 33, but one also sees the context of it.
Yes.
So the context of it, the content of it, is doing the kind of signposting exercise I think that my lord is talking about, which is this is what we're going to do.
Yeah.
And we're going to develop more. So we're going to do two things. First of all, it will support delivery of net zero. So it's not a food strategy that only deals with, let's say, dietary preference or health or whatever. It's a food strategy that is grounded in net zero as well. But it's telling the reader, telling Parliament and the CCC and so on, what we are doing and going to do on the way to that. Exploring options to reduce carbon emissions is part of that food strategy process, but that's the content of the paragraph. Contextually, this is in the section under the heading Policies and Proposals, see page 351. It's not in the, there's a whole narrative part to the chapter which I jumped over perhaps too quickly, which is describing a whole load of things going on, the situation and all what's going on. This is in the context of telling Parliament and the world that this is one of our policies and proposals. So the policy and proposal is not merely a narrative description. This is itself one of the Section 13 policies and proposals. We will do these things. And that's why Sarah James is correct to describe, it reinforces the point, in her SJ13 table, correct to describe it as one of the policies and proposals, and unquantified, which it clearly is, in that framework. So we say, and the court may disagree, but this is our submission, we say that that process, that unfinished business, if you like, then means that assuming Section 13 is more than just a periodic adjunct to Section 14, which we say would be a wrong reading of the statutory framework, assuming it has life in between times, we say this is an example, not necessarily the only example, of where Section 13 would then be engaged in that process. You've left, you're trying to fill your 5% shortfall, which you permissibly left. In filling the 5% shortfall, you have this leftover legacy bit, activity of producing a food strategy. When you then get to the food strategy production, I'm going to step over the line into content now, you need to look at, we submit, but it's not for this court, things like quantification, timescale and risk of delivery. Because that's what, taken together, see Mr. Justice Holgate compositely, gives the Secretary of State the necessary confidence to reach the overall economy-wide evaluation that he or she has to undertake. And everything about the way in which, Mr. Justice Holgate, in a sense, kicks this off by describing it perfectly permissible to have policies and proposals that are evolving. It's perfectly permissible to have policies and proposals that change over time. Everybody agrees with all of those things. And we're not seeking to pin scrutiny, if you like, on the workings out that goes on in between times. We're simply saying that in this instance, where you leave it over...
Well, that's the question. That's the critical question.
Of course it is.
Have they left it over, or are they simply making a prediction that the food strategy, when it comes, it will support, etc., etc.?
My lord, I understand how that analysis, use my words carefully, that analysis would have greater force if you read that paragraph in isolation.
Yes.
And particularly if you read that paragraph in the body narrative of the document, indeed, but you don't. You read it in the section called Policies and Proposals, where every single other paragraph is some of them are more specific and more obviously quantifiable than others. And if you track through the Sarah James SJ13 table, her exercise after the Net Zero Strategy document was produced, conscientious civil service process is to go through, pulling out each of the paragraphs under a heading of policies and proposals and telling you its status.
But applying the logic of your submission 5 minutes ago about the inadmissibility of officials' opinions, why is Sarah James's SJ13 admissible on this point?
Because that's not merely her opinions. That she presented it to court, yes, as an exhibit, a witness statement called SJ13.
Yes,
but
she says, forgive me, she says that this is how you should understand the NZS. Well, why does that necessarily follow? Why can't we just read the NZS, which is a published document placed before Parliament, which doesn't on its face say we're leaving this over. What it says is our prediction is that the food strategy, which is upcoming, will support the delivery of net zero.
Well, in my submission, it's not merely a prediction; it's a commitment.
Right.
It's not merely it's a sort of I can't say any better than that. You get the point.
Yeah.
And so just to understand Sarah James's document, it was presented to the court in a form of an exhibit to a witness statement. But the way it's described, and that's partly why I took you to her witness statement, is that what she's transcribed into the thing called SJ13 was effectively a contemporaneous document. This wasn't her doing an exercise for the court. Although I suspect what happened was there was a cut and paste exercise of the document she produced into something and then had a header SJ13. Who knows how it was produced? But that was the point of her witness statement when she says in terms, I and my colleagues, after the net zero strategy was published, she doesn't tell us when, produced this table. So that was the department's understanding at that point in time, whenever it was. Not her understanding produced for litigation, although it's kind of packaged that way.
Right.
Does that?
Yes, thank you.
But I also, so first of all, the will support is not, my submission, merely predictive, it's promissory, is that the right word? I don't know. But it comes, and I come back to the point, it's in a section called Policies and Proposals. And you haven't got the other chapters of the net zero strategy, but they all follow the same structure, which is opening paragraphs, narrative, if you like, and then something more concrete. And that's how we say Parliament and the court would have and should now read it. And that's certainly how
Mr. Wolfe, does it really boil down to this, that what you say is that, bearing in mind the context and the heading and the chapter in which it appears, the inexorable inference to be drawn by the reader is that one of the policies that is being adopted by the government to meet the 5% shortfall is this strategy?
Yes. I mean, I haven't shown you can get the 5% from other. You haven't got the net zero strategy at 5%. But if this was the claimants in that case came into it saying you've only quantified 95%. You've got these other things around, of which I don't think they focus on food strategy because it's one of several. But this is one of the things you've got in place, and that's impermissible. They said. Mr. Justice Holgate said not impermissible. You can have that kind of policy, but it's there to help fill the gap.
Is another way of putting this, Mr. Wolfe, I genuinely want your...
No, I'm happy to help, my lord.
Yeah. Is another way of putting it that the accident of timing can't make all the difference to whether Section 13 applies or not? That if the food strategy had been available in October 2021, they would have referred to it, you say, as being one of the policies which will enable, etc., the language of Section 13.
Yes.
And so what's happened, as I understand it, you submit, is that it wasn't available at that time. It wasn't ready yet. But that can't make any difference to the conceptual analysis. If Section 13 would have applied to it if it had been ready in time, then it can't suddenly not apply just because it isn't ready for another year. Is that how you put it?
Yes. I need to be careful not to go too far. I mean, certainly what we have in other paragraphs, and you've only got a selection of them because you only got part of the document, is some of these other references. Let me try and put it this way: under let's say the agriculture heading, which you've got in front of you, some of those are in other documents that you might have called them a policy on something. And so those are examples of the kind of thing that I think my lord is contemplating. And this is reporting our existing, some of them would have been published, some of them weren't published at the time, but this is our presentation. And our presentation includes, partly filling in the 5% gap, amongst other things, this process, which we're promising, which will lead to something which, had we, my lord's accident of timing point, had we had it now, we'd have given you now, but we haven't got it now. Claimants in that case complained about that. We're told that their complaint was flawed. It can't then be right that you can, on the one hand, see Mr. Justice Holgate push it down the track, and on the other hand, not give it the same qualities. I don't necessarily say scrutiny, but the same qualities as at this point. And that's why we don't arguments earlier parts of the case about how far you'd go on Section 13. We don't make a case beyond this one just to be very clear. Because we don't say that you kind of bring the Section 13 magnifying glass down on every piece of paper all the way through across government, and that would be bonkers. But that's the extreme case.
Well, I can well understand the argument that you can't, as you say, just push it down the track. You can push it down the track until you formulate the policies and strategies that have been left over.
Yeah.
And I think your argument is that when those policies and strategies are being formulated with a mind to making up the shortfall, then the duties are engaged under Section 13 with all the concomitant rights and obligations. That I understand that argument completely. But that begs the question of whether what you're pushing down the track has already been sufficiently identified as a shortfall policy. And the argument against you is that this was never intended as a shortfall policy. It was a separate policy, which was intended, if you like, as a supplement or a boost.
Well, then we come back to how one understands the contemporary document,
yes,
as opposed to how one understands the witness statements presented for this court, and that's why I deliberately went to that.
More than that, doesn't it? With respect, you say that witness statements don't help. So you've actually got to go back to the primary documentation, and it comes back to it's a necessary inference that this strategy has been already identified as one of those proposals.
It's a necessary inference. You mean from the net zero strategy?
Yes.
Yes, that's right, yes. And we don't shy away from that case.
No.
It's a net zero strategy. You can look at several layers. You can look at the net zero strategy on its own. Read the paragraph, what does it say? Read it in context, what does it say?
And then you say supported by
the contemporaneous documents which happen to come out through the process of prior the net zero strategy case.
Well, that's helpful.
Some of which. So the two things we rely on. I rely on the ministerial submission, which described to the minister this process of we're relying on future evolution of policies to fill the gap.
Yeah.
That's ministerial submission, contemporaneous documents, and SJ13, which I hope the court now understands, at least our understanding, and I'll be told if I'm wrong, is that it is in effect a contemporaneous document, and that was Sarah James's para 161, I think it was, describing how they produced it.
You say the two link up. The ministerial submission predicts that there's going to be something done.
Yep.
And SJ13 is the something being done.
Well, SJ13 is a. I'm not quite sure I'd say that. SJ13 is the list that was produced by the civil servants shortly after. We don't know how shortly after the net zero strategy. The way it looks is it's almost like a checklist. We've gone through. We gave the minister Annex C.
Yes.
Annex C was the directly quantified ones.
Yes.
That was the 95%. What we've now done is we've gone through, and you can track it. The paragraphs in SJ13 are the paragraphs
In what the minister
in the net zero strategy from the sections of the net zero strategy which are called policies and proposals. It's a very diligent mapping exercise. You haven't got everything to be able to repeat that exercise, but you've got the bit for this chapter.
Yeah. Could I just return to the necessary inference, or inexorable inference, as it was put earlier? That is to be found in paragraph 33, and only paragraph 33?
Well, 33 in context, that's the important thing.
So the necessary inference is reading paragraph 33 in context.
Yes. I hadn't thought about my Lord Justice Singh's use of the word will until today, and it's helpful to have that probed. If you literally read that first sentence or that first phrase in isolation, I could see that you might read this as being purely predictive. But first of all, the second part of the paragraph tells you about action, is exploring options to reduce carbon emissions. So that's about action, not merely about, it's promising action, not merely predicting events. And if you then look at that, as I say, sorry to be repetitious, in the context of heading on the previous page, policies proposals, it is one of the long list, and there's, as I say, repeats chapter by chapter, which fit that category. In a policy or a proposal, Mr. Justice Holgate's analysis, we the claimants were forced to accept that policy and proposal could be widely framed, they could be evolving, they didn't have to be finalised. So once you accept all that package of things, then this is entirely consistent with, and we say necessarily, part of that framework.
So the immediate context, at least, would be paragraphs 24 to 34.
Immediate, yeah, yes, and I think
Sorry, no, it
you've
goes
got
beyond that.
so if you go back to page 340, and that's the macro context page.
Yeah, actually, I'm wrong. I should have said, I think, everything that appears under the heading policies and proposals, which runs up to
Yes, because it goes beyond agriculture.
51.
This chapter, if you go back to the beginning of this chapter is natural resources. That's 3.6 on page 343. Within that, as my lord says, the heading, there's a progress to date, starts on page 344. So the first 23 paragraphs are progress to date. Then you have policy and proposals. That's what this document is setting up. And it goes beyond 33, because it's up to 33 and on.
If you look at the hierarchy of headings, if one wants to call it that, I think it makes sense to say that the immediate context might be paragraphs 24 through to 51.
Indeed. And then the wider context, I mean, we can get you the whole document if you want, but you've got page 340, you've got the contents page of the document, and we've been looking at chapter 3 sub 6, little Roman 6. You'd see the structure that we've just been looking at replicated in each of the 3.1, 3.2 and so on. They all follow that same structure, and Sarah James's SJ13, which is a contemporaneous not witness statement document, picks up those paragraphs and then as she described in her witness statement, says quantified or unquantified.
So is this effectively equating the identification of the food strategy in paragraph 33 with, for example, going on to paragraph 43, the promise to publish the biomass strategy, and 44, the government's resources and waste strategy? These things will do this and that. So by parity of reasoning, you're saying that those strategies also fall within section 13?
I think you need to look at. I think the answer, yes, is the short answer to my lady's question. But one would need to look at each paragraph to see what's being described.
Well, they're all policies and proposals.
Yes.
Falling under subheadings.
Yeah. But I'm just accepting I think flowed from my exchange with Lord Justice Singh earlier on, which is you look at the words in the paragraph and the context, and so I think the answer to those is, but it's I'm just don't want to go beyond the case that we're advancing unnecessarily, if you see what I mean.
Well, I'm just thinking logically.
Yeah.
What's sauce for the goose? Because
so some of those, for
be
example,
a specifically identified strategy within this chapter. You say in context, because it's a policy and proposal, and because there's this shortfall, has got to engage the requirements under section 13, and by parity of reasoning, that must cover every strategy that is specifically referred to in this chapter.
I'm just looking to see if. What Sarah James said about those ones. I think that's right, my lady. But I may just reflect on that if I may.
Yes, of course.
Mr. Wolf, before we, sorry, had you finished on that?
No, please do.
May I, before we leave this page, can I just ask you a couple of questions, which I hope reflect the way it's put against you, because I think one of the points that's made against you is that the NZS itself laid down certain steers for the food strategy, and that the food strategy complies with those steers. And what I think is meant is that if you look at the second half of paragraph 33, which, as you reminded us, is part of the context in which we should read the first half, government is exploring options to reduce carbon emissions from food production, support innovation in the food sector, incentivise land use change, and preserve natural resources. Now, if you look at the first of those, exploring options to reduce carbon emissions from food production, some more detail is given in the left-hand margin, paragraph 31, and in particular the fifth line onwards. For example, ruminant livestock are the leading cause of farm emissions. that feed additives with methane inhibiting properties have the potential to reduce emissions, especially from housed cattle. It's an emerging technology. Government is actively investigating the promising role these products may have in delivering emission savings in the mid-term. Could it be said that this has therefore given a steer to what the food strategy should contain, and that what the point that's made against you is that what it certainly does not give a steer about is reduction, for example, in meat consumption or dairy products is going to be part of what the NZS is envisaging will be in the food strategy, which will support the delivery of net zero.
I understand that, my lord, and that's why very clearly our case is not predicated on whether or not diet change, if I can just use that label for the moment, where it sits in this process. Our case is around, this part of the case anyway, is in relation to the engagement of Section 13, in relation to what it did.
Yes, but I think
not in relation to what it might have done or didn't do.
But why can't it be said against you that your argument that Section 13 applied to the food strategy fails at this hurdle, that it didn't apply because this had already given steers as to what the NZS expected would be the factors in the food strategy which would contribute to delivery of net zero?
I think I may be being very dim, but I don't have a problem with that proposition. Let's say, purpose of argument, it was giving a steer. First of all, we say it's not exhaustive, but nor could it be. But even if you said this is the steer, we say in relation to that which is steered. Let me just pick up that Section 13 applied. Right. Not necessarily in relation. Now, my clients would like there to have been other things in the food strategy. That's a given, but that's not a stepping off point for our argument about engagement. Section 13. That's why I was very clear, I hope, in opened it without reference to diet, disabusing the defendant and the court, I hope, of any reliance on diet as being the engaging factor one way or the other, see what I mean? And therefore, I'm happy to accept, for this purpose at least, that the food strategy is giving you some signposts, that it didn't signpost diet, and indeed the CCC picked that up, we'll come to that in a moment, but in whatever it was it signposted and whatever it was it did, we say Section 13 was engaged.
I see.
So Section 13 was engaged in the exercise it actually did. Right. And it would have been engaged in a different exercise had they done what my clients wanted, but that's not the issue. We don't need that bit.
So Section 13 was engaged by virtue of the signposts?
By virtue of the, well, that's a very compacted way of putting it, but I think we know, yes, I think, yes.
Well,
yes.
I'm trying to get the essential point.
It's not merely a signpost, it's how it sat within the Section 14 report.
Yeah.
And the role the reliance that was placed upon it, and the role it was playing in meeting the shortfall going forward, and what my Lord Justice Singh called the accident of timing point. I mean, they're all different ways, I think, of describing the same situation. It's inchoate, that's another word that's been used in the materials.
Well, if you use the same imagery, it would be a journey yet to be completed, I suppose. That's what inchoate means in this sense. Yeah. So these paragraphs, read properly in context, are pointing to a journey begun but not completed.
Yes. And you're being told, you the reader, CCC Parliament, this is how we're going to help fill the shortfall. It sort of doesn't matter, and there's an elaborate argument about what kind of policies and proposals and so on. Again, our case doesn't depend upon that. It is a policy proposal. We know that Section 13 can apply to it's a very flexible beast in terms of what's meant by policies and proposals. It's not like policies in the Planning Act. It's not like all of those other much tighter versions of policies that this court's seen before.
Thank you. So by all means, take a moment.
No, I think then the third issue in relation to Section 13 engagement. So I dealt with the sort of evidence inadmissibility point. The second is the misunderstanding of our case point, and the third is the identity of the minister point. If I can put it that way.
Yes, fine. So we're going on to that now.
My lord, yes.
Right.
So an argument against us is that the food strategy on its face is produced by the Secretary of State for Environment, Food and Rural Affairs, and so it is said, or by contrast, so it is said, Section 13 is a policy that can only ever be exercised by the, as was then, Secretary of State for Bays, as now is Secretary of State for Energy, Security and Net Zero.
Yeah.
We say, in a sense, that's a dead end. It doesn't matter, but let me just deal with the steps on the way to that point in any event. In terms of the statutory understanding, the constitutional understanding of the Secretary of State, so you've got the words in the Act, the Secretary of State's duty in Section 13. If you just bring to hand the legal materials bundle, please. Within that you have tab 2, Interpretation Act, page 12 of the bundle, if you're working from page numbers. And in that page 15, definitions. In any act, unless a contrary intention applies, words and expressions listed in Schedule 1 of this Act are to be construed in accordance with this schedule. The schedule starts on page 19, and within it on page 23, I think it's the fourth entry, but it's a slightly confusing document. Secretary of State, by the upper hole punch anyway. Secretary of State means one of Her Majesty's principal Secretaries of State. So that's the version of that. You then have in tab 10 the Bapio Action Limited case, one of them. Within that, at page 154, paragraph 33 and 34, Lord Roger, describing the position of the executive power of the Crown, is in practice exercised by a single body of ministers make up Her Majesty's government. With the increased range of responsibilities of central government today, there are, of course, more ministries dealing with domestic affairs than there were, but they all exist to carry out the policies of government, as this case illustrates. ... Next paragraph. I am accordingly satisfied it would be wrong, not only as a matter of constitutional theory, but as a matter of substance, to put the powers, duties and responsibilities of the Secretary of State for the Home Department into a separate box from those Secretary of State for Health, both the formulating and implementing policies of a single entity, Her Majesty's government. And we agree with that. We say that applies here. This may say Secretary of State, and that may in practice, and I'll come to the practice in a moment, be allocated as a day-to-day function to the Secretary of State for Bays, as was. But the principle is that whoever is doing it, they're doing it on behalf of Her Majesty's government, and the basic overarching proposition is that this is an obligation on the government to produce carbon budgets, policy proposals, and so on. And you'll see, if we get into the materials, that's how it's done. The net zero strategy was signed off not simply by the Secretary of State for Bays, but by a government, and likewise the food strategy was signed off not simply by the Secretary of State for Environment, Food and Rural Affairs, but more generally. And we say those practical things are part of the context here. You then also, if I can put that bundle down, you have in the supplementary bundle number 1 at page 447. This is mechanics paperwork rather than legal paperwork. 447, you have the ministerial code of the Cabinet Office from 2002.
Sorry, Mr. Will, could you please give me that reference?
Sorry,
again?
it's SB1, page 447, is the title page.
Thank you.
I want to look at 449, please. Heading is ministers and their departments. 4.1, the Prime Minister is responsible for the overall organisation of the executive and the allocation of functions between ministers in charge of departments. And then you have the very beginning of that bundle, SB1, page 3, the Cabinet Manual.
Sorry, the reference again?
SB13.
SB13.
3, page 3.
Sorry.
At SB16, which is the internal inside. The heading above para 325, powers granted by Parliament. Many acts of Parliament grant powers to ministers or place statutory duties on ministers. Then 326, most statutory powers and duties are conferred on Secretary of State. That's the statutory framework. These may be exercised or complied with by any of the Secretaries of State. This reflects the doctrine there is only one office of Secretary of State, even though it's well-established practice for more than one person to carry out the functions of the office. 327, it's also excuse me, the well-established practice for each Secretary of State to be allocated responsibility by the Prime Minister for a particular department, for example, and accordingly for each Secretary of State in practice to exercise only those functions that are within that department. It's for the Prime Minister to determine the various departments. See so-and-so on mechanics. And then you have those paragraphs, the 355 paragraphs referenced there, over the page on page 8. Machinery of government changes. Prime Minister has responsibility for machinery of government changes. The Prime Minister's written approval must be sought where proposals transfer functions between ministers, etc. So sometimes, we haven't got an example of that, something is allocated only to one person, and very clearly so, mostly financial things. But generally they are following this framework here. And we say that so far, and there's another step to it, there is nothing in that framework that says that Secretary of State necessarily means or only means the Secretary of State for Bays as opposed to the Secretary of State for Environment, Food and Rural Affairs.
But that submission I understand, but many contexts, like the ones that have been referred to in these documents, are permissive. In other words, Secretary of State has a power to do something. And it's well established in constitutional law that that power can, in principle, be exercised by any Secretary of State. But how is it supposed to work where you have a duty imposed on the Secretary of State? Section 13 is a duty. Now, leave aside the facts of this case. Suppose you didn't have the net zero strategy. Suppose you for the first time ever, Section 13 has to be complied with. If the duty falls upon each and every Secretary of State, and as you've said, proposals and policies is very broad, so it can be but just about anything they're doing, and it can include emerging policies. So how on earth is an individual Secretary of State supposed to know whether what they're doing is going to contribute to the overall strategic goal which Section 13 sets?
Well, there may be some policies proposals, probably most of what's being done by government most of the time is nothing to do with climate change. So obviously those policies and proposals are unconnected to climate change. However, once you have a policy and proposal which is being contemplated to contribute towards or designed to contribute towards meeting those net zero climate change aspirations, Section 13 is potentially engaged. Section 13 is potentially engaged. So not when you're doing a policy which is nothing to do with climate change, but it's potentially engaged at that point. Then the question of whether it's engaged depends in part on the identity of the Secretary of State, but in part on the task. And that's where we go back then. This is not a constitutional question asked in a vacuum. It's asked in the content of Section 13. So Section 13 operates at multiple levels. One level is the whole economy level. There's the taken as a whole language in Section 13.3 relating to sustainable development, but that's also implicit in 13.1 and 13.2 because that is about meeting the net zero 2050 and the carbon budgets on the way. And that whole economy evaluation of does this package together, adding up all the bits and the bits that we haven't yet worked out, add up to the requisite number, we accept that's an activity that can only be done by the Secretary of State for Bays or whoever it is who's given that job. But the Secretary of State for Bays is not the one working up the policies around the place, the policies on aviation or agriculture or heat or whatever it may be. Those things are being done by Secretaries of State around the place, and we have examples of that here. Secretary of State for DEFRA is working on agriculture and food policies within their remit. Now, if Section 13 had no content, then the submission I'm about to make would have no traction. But Section 13 has content at the level of policies and proposals. See Mr. Justice Holgate, and that's an important stepping off point. Section 13 is not only engaged when you do the macro analysis. That's why Mr. Justice Holgate's judgment in the Net Zero case is so important, because what he said, there directed at the Secretary of State for Bays, was this isn't just about your total calculation, it's about each policy and proposal that's in the composite. For each policy and proposal in the composite, you need to, he said, if it's quantified and relied on, have the quantification, have the delivery risk, and have the timescale information. That is information related to that particular policy. So when you have a Secretary of State for the Environment, Food and Rural Affairs working on a food strategy with, let's say, sub-policies within it, that's perfectly permissible. Those types of issue, delivery risk, timescale and quantification, are, at least in the first instance, for that Secretary of State, And there's nothing unconstitutional about that. There's nothing inconsistent with the Climate Change Act. And indeed, it makes obvious practical common sense, because otherwise the Secretary of State for Bays is basically having to adopt, make up, evolve all of the policies across the whole of government that make up the constituent components of the Section 13 exercise or the Section 14 exercise. It necessarily, Section 13 necessarily, we say, implies some form of disaggregation. So there's nothing surprising then in saying Secretary of State for the Environment, Food and Rural Affairs is not looking at the total figure, how does this fit in within the 95% or the 5%, but is looking at, just to use delivery risk as an example, am I here relying or contemplating relying on something which is very tangible, very doable, and I can say with confidence we can do it next year and it will deliver X or not deliver Y? Or am I talking about something which is wildly aspirational, which is some mad scientist's dream project? That's the delivery risk point. And that feeds in to that Secretary of State's evaluation of their contribution to the total picture. And that's how it builds up. Now, so that's how we say the Secretary of State for Food and Rural Affairs is the appropriate person to do that exercise for the food strategy at that content level, if you like. However, that's why I started off my submissions on this point saying it doesn't matter. Even if we're completely wrong about that, even if this was only ever for the Secretary of State for Bays, then what we see here, thanks to this court directing that the Secretary of State for Bays take part in the litigation as a second defendant and explain himself, which has been very helpful, is we see civil servants from Bays quite understandably and rightly involved, not in the widgeting the detail of food policy or whatever it might be, but in assessing the Section 13 type factors. And that leads to a process whereby they say they're checking for consistency between the food strategy and the net zero strategy. That's what was going on at the time because they didn't understand what Section 13 required. But what they were doing at the time was precisely providing the Secretary of State for Bays involvement, oversight, whatever it may be, in the exercise being conducted by the Secretary of State for Food and Rural Affairs, policy content exercise. And then we see at the end of the process, Mr. Thompson describes it in his witness statement, the food strategy is signed off, goes around the whole government, signed off by the whole of government entirely properly. That's drawing together in quite an elegant and nuanced, we say, an entirely permissible way, the components of how Section 13, which is an unusual cross-government, if you like, obligation, how that disaggregates in terms of who does what. And it is a cross-government obligation because climate change is a cross-government problem and therefore requires action by everybody. It's not like so many other things which can be positioned in one department and they can take ownership. Sorry, that's a horrible modern phrase. They can be responsible for delivering it, measuring it, formulating it, delivering it, measuring it, and so on. Here, you necessarily involve people across the constitutional piece, and the sort of Interpretation Act route into that, the Ministerial Code route into that, and the Section 13 route into that, all kind of come good in the end. That's why we have always been happy to say this is an obligation falling either on the Secretary of State for Environment, Food and Rural Affairs or on Secretary of State for Bays. When we came into this case, we said Secretary of State for Food and Rural Affairs because we didn't know about the involvement behind the scenes. I don't mean behind the scenes in a rude sense, but in the process. We're now happy to say, well, it was the Secretary of State for Bays. But in our submission, the defendants can't escape the obligation falling on anybody by just pointing at each other and saying, not me.
Yes, in one sense, what you're saying is that the obligation falls on the government.
Yeah, the government, exactly.
And one of I don't want to distract you now, but one of the difficulties that British constitutional law has always had is that we don't have in law the concept of the state.
No.
You can sue the state in international law, but we don't have the concept of the state within domestic law. That's why we have to sue, for example, the Secretary of State for X, Y, and Z.
I think I've covered off that ground. I don't think I need to say any more. But that's why we say, in a sense, this is a non-question. It doesn't deal with the Section 13 engagement question. So that really is the so ground one is was Section 13 engaged? We say yes, and there's no argument against about content. What's faced with ground two, the one that was called reformulated or is reformulated previously, is parasitic on that. We understand this, but it's important because it takes us to an important place, which is the role of the CCC's advice. Can I just ask you then to pull to hand the legal materials bundle?
Yeah.
Within that, please tab 22. Decision of the Lord Senior President in the case of Wyatt. So the context here is not critical but relevant. Context here was advice from Natural England informing a decision, a planning decision arising from the Habitats Directive and the Habitats Regulations, Regulation 63 of the Habitats Regulations. We see that in holding number 2. I mention that simply because this wasn't a context in which there was a statutory duty to consult or a statutory duty to advise that was focused on Regulation 63. Natural England is set up as a generic statutory advisor, and as a matter of practice and protocol, it advises on the Regulation 63 exercise in some cases, not in all cases, but in some cases. And that's what happened here. So this is not a situation. So I mention all this because I'm obviously contrasting some of the statutory dialogue which occurs in the Climate Change Act, where it says the Secretary of State shall consult and the Climate Change Committee shall advise. It's not one of those, but I don't need to be in one of those, is the point I'm making.
Right.
And then within that, you have at page 666, it's under basic points, paragraph number 9, and we go to page 668, paragraph 9.4. Competent authority is entitled and can be expected. So competent authority there was Secretary of State in the context of planning decision. We say here, Secretary of State in the context of Section 13 exercise. Entitled and can be expected to give significant weight to the advice of a, quotes, expert national agency with relevant expertise in the sphere of nature conservation. So yes, this paragraph on its face is limited to that, but it's clearly going beyond the facts of the case. So it was stating a more general principle than just Regulation 63. And so it's not the words nature conservation in my submission don't add to that because it was not limited to Regulation 63, such as, again, not limited to Regulation 63 or even, we say, nature conservation, Natural England, see the judgment of Lord Justice Sales in Smith, etc. The authority may lawfully disagree with and depart from such advice, but if it does, it must have cogent reasons for doing so. See Baroness Hale in Morge, Lord Justice Sales in Smith, and Prideaux, and so on. And the court, for its part, will give appropriate deference to the views of expert regulatory bodies. See, for example, the judgment of Lord Justice Beatson in Mott. So the critical components of that are, is this engaged? Is this a situation to which the regulation, 9.4 applies? Is this a Wyatt advisor advising on a Wyatt topic, my characterisation? And if so, give significant weight and cogent reasons for departing. Now again, just to be clear, the Secretaries of State, the defendants, very helpfully make clear they are not making a positive case. They are not saying that the Secretary of State for the Environment or the Secretary of State for Bays did the significant weight exercise or did the cogent reasons exercise in relation to the food strategy. So the issue, in relation to the CCC's advice in relation to food strategy, so the issue here is the engagement one, it's the pure engagement one, which is premised, and we accept this, and I'll show you why in a second, on Section 13 being engaged. So this is parasitic entirely on first ground. That matters because the Section 13 engagement point, because that's the context in which we have the exercise being conducted. And that matters because, go back to what I said earlier in the morning, in the context of that exercise, the CCC has a role to advise. That's the point I made this morning about Section 10 in particular. Section 10, just to remind the court of it, was at page 40 of the court's bundle. The following matters must be taken into account. By the Secretary of State in coming to any decision under this part relating to carbon budgets. So any decision under this part relating to carbon budgets, and Section 13 is one of those. And by the Committee on Climate Change in considering its advice in relation to any such decision. So we failed to get permission, and we obviously don't persist with an argument that this was, in a common law sense, and obviously material consideration. It's a statutory consideration arising, and there's more to it than this, but partly in the context of the Section 10 engagement of the CCC giving advice in relation to...
I'm not following this. The duty imposed by subsection 1 is first imposed on the Secretary of State. The first duty is imposed on the Secretary of State.
1A.
Yeah, exactly. Yes. And so what the Secretary of State has to do is must take into account the matters which are then listed in subsection 2. Is
Exactly
that
right? Yes.
Well, where does it say the Secretary of State has to take into account the advice of the Committee on Climate
sorry,
Change?
that wasn't the point I was making.
Sorry.
If that was the mistake, my mistake.
Right.
It's 10.1b.
Yeah.
Is by the Committee on Climate Change, which takes into account the same factors in formulating its advice.
Yes.
That's the important point.
Yeah, but why does the Secretary of State have to take their advice into account?
Well, in my submission, can I come to that in a second? Before I get to there, can I just look a little bit at the CCC itself while we're now back into the Climate Change Act? I said I would come back to the stuff about the CCC's nature and so on. You have that starting on page 53, if you would. Committee on Climate Change is the heading. Section 32, there shall be a body corporate known as, and then 32.2, Schedule 1 contains further provisions. Just before I come back to the rest of that section, can we look then at Schedule 1? You have that on page 69. Schedule 1, the Committee on Climate Change, so in quite a common structure in setting up this kind of body, the details of its mechanics are set out in the schedule. So membership, the committee shall consist of, obviously, a chair plus 5 to 8 other members. And then section 1.3, in appointing a member, the national authorities must have regard to the desirability of securing that the committee, taken as a whole, has experience in or knowledge of the following. And then there's a range of things. So this is set up as a committee which has to have a prescribed statutory expertise within its members, if you like, which is, and we go back then to the body of the legislation, which is under a duty in various specific ways to give specific advice. Section 33, advice on level of 2050 target. Section 34, advice in connection with carbon budgets. Section 36, reports on progress. And then there's a section 37, response to committee reports on progress. And then 38, duty to provide assistance or other assistance on request. So there are specific situations in which there's a duty to advise and a duty, we saw earlier in the morning, to take into account. But the point is, and we get this further from Mr. Justice Holgate in a second, which I'll go to, the point I made earlier on, that is not an exhaustive list of situations in which the committee advises. And we get this if we need to, and that's where I perhaps took it out of order, from Section 10. Because Section 10 is clear that the Committee on Climate Change can advise in relation to any of the functions related to carbon budgets, which we say includes...
No, I understand they can. They have that power.
Yes.
So they're not acting unlawfully if they do choose to advise. But where do we find an obligation on the part of the Secretary of State to have regard to what they want?
Well, we say that's implicit within the statutory scheme because Section 10 goes beyond, so it's slightly repetitious, the specific context of advising, the ones that are pulled out for particular attention. There must be, we say, a co-relative obligation on the Secretary of State to have regard to their advice. Can I just pick that up in Mr. Justice Holgate, if I may? You have his judgment. This is the bit that I can take you to. It's page 615. In your legal materials bundle, tab 21. Paragraphs 50 through 55. 50 through 53 really pick up what we've covered so far. Section 54. Section 37 obliges Secretary of State to lay before Parliament a response to the points raised by the CCC annual report. And then Section 38(1), this is paragraph 55, requires the CCC to provide advice or other assistance requested by a national authority in connection with the functions under the CCA, progress towards meeting the objectives set by the statute, and any other matter related to climate change. Section 39 gives the CCC a general ancillary power to do anything that appears necessary or appropriate in connection with its functions. I accept the submission by Mr. Honey QC on behalf of the Secretary of State that sections 38 and 39 enable the CCC to engage in ongoing dialogue with the Secretary of State and to respond publicly to documents he publishes, such as the NZS. So that's another way, more elegantly put by Mr. Justice Holgate than I do. This framework creates what he describes as a dialogue. And sometimes the advice will come in a progress report or a statutory report. Sometimes it will come in another form. And what he helpfully identifies there is the words at the top of 616, the responding publicly to documents such as the net zero strategy. Because what we have here, as an example of that, is we have the Committee on Climate Change publicly commenting, publicly advising on the net zero strategy, which isn't one of the statutory obligations in relation to the specific elements, but we say does fall, and falls very clearly, within the Section 10 framework and, see Mr. Justice Holgate, the wider dialogue framework. So, A, they have the power to do it, and B, we say, this necessarily implies the Secretary of State needs to take into account their advice. And we say that engages the Wyatt framework, which isn't, go back to Wyatt itself, dependent upon there being a specific statutory dialogue, if you like, about the point in issue. I mean, actually, we're in a stronger position, if I can put it this way, than in the Wyatt case, because Wyatt is in the context of Regulation 63, which says nothing. Regulation 63 is purely implementing Habitats Directive and says nothing about advisors. Has nothing about advisors. Whereas here we have, in this context, statutory advisors who see Section 10, specifically statutorily can advise on, amongst other things, Section 13. So we're in a stronger position than the legal framework around Wyatt. So we say that the Wyatt obligations apply here. There's no positive claim from the defendants to say that they complied with those obligations.
Does the Secretary of State in this litigation say that they did not have regard to the committee's advice, or that they did have regard to it, but they decided to depart from it for good reason?
So as I understand their case, and I don't want to make their case for them, what they say is the Secretary of State for Environment, Food and Rural Affairs had regard to,
right.
And there's important steps on the way, because Wyatt is not merely a having regard to obligation.
Yeah, I understand that.
Had regard to, was aware of, and we've got information related to that in the bundle, the CCC's advice on diet. And I think that's as far as they go, right. And understandably so.
That's helpful.
They don't make a claim, a significant weight claim, and they don't make a cogent reasons claim. Let me take this in two steps. They don't make that in relation, they make the considered point in relation to the period up to the net zero strategy, but they don't make the further claims about significant weight, serious weight, and cogent reasons in relation to that period. They make none of those claims in relation to the food strategy period. Now, we are not litigating the first period. We're only litigating the second period. But it's not a case where they say, the consideration that the Secretary of State gave in that earlier period somehow, as a matter of fact, absolved him from needing to do it in the second period. You might have seen an argument that said the Secretary of State looked at this, understood it, gave it significant weight, and here are his cogent reasons for departing. Didn't need to look again. But that's not the case made against us. So we're not unconcerned about the earlier period, in the sense that it doesn't provide an answer to the later period. We're concerned about the later period. So I hope that makes sense.
Yes, thank you.
In one sense, the court's not terribly concerned about the detail of what the advice was in that instant, what flows from that. We've set this all out in our materials. The point I would make simply is this: the advice came in more than one type of report. So it came in the 2020 progress report. So that was a statutory progress report. You've got that at SB 113. We can look at that if we need to. It came in the 6th budget advice. Again, another form of specific statutory advice. So there's no question about the provenance of it in that sense. That's SB 119 and SB 1576. It then came again in the next year's progress report. That's SB 141.
141.
So 41, I'm sorry.
41, yeah.
That progress report is worth just picking up one document. So the progress report to which the Secretary of State needed to give a response, the response is at page 578. SB 1578, I should say. So the summary, the foot of 578, the left-hand column heading is agricultural food, and then the last row on 578, the CCC advice, if you like, was implement measures to encourage consumers to shift diets and reduce food waste. So shift diets and reduce food waste, two separate ideas, as we'll see in a second. So number one, low-cost, low-regret actions to encourage shift away from meat, etc. And then two is reduce food waste. So the opening words of the paraphrase include, as you see, the two different elements, and then the response, which is the right-hand column starting on 578, running down the page, only relates to waste. So no complaint is made about that, but there's no, it's just the observation is there's no response in relation to the diet element. And the point about this document is that this document is produced on the same day (19th of October) as the net zero strategy. So that's why we say there's no in the public-private documents there's no serious consideration, cogent reasons for departing from. This is just a public version of that. The CCC, then this is page 361. So all the things I've shown you before so far are pre-net zero strategy. 361, October 2021. This is the document Mr. Justice Holgate was referring to as being permitted by the dialogue, if you like. So this is not produced pursuant to any of the specific statutory obligations. So it's a Section 10 type obligation, although I think Mr. Justice Holgate saw it as a Section 38 type obligation. And in the aftermath of the net zero strategy, page 363 and then over the page at 364, they're different places from the document, we appreciate. But first of all, we see on 363, halfway down the page there's a paragraph by the tiny writing, another clear difference. So the committee is saying, effectively noting that you haven't done what we suggested, Another clear difference from the committee scenarios is on the contribution from changes in behaviour. The net zero strategy and the earlier transport decarbonisation plan include ambitious goals for shifting travel choices away from private cars, such as by doubling cycling. However, the strategy has nothing to say on diet changes away from meat and dairy or on limiting the growth in flying, two separate ideas. So
I'm so sorry, Mr. Wolf, it's my fault. Oh, I see, it's 363. I was on 364.
I'm sorry, So it's noting the point, in a sense, we discussed earlier on, which is that the net zero strategy is silent on diet. The CCC, clever people that they are, noticed that, and then over the page, not over the page in the document, but over the page of the court's bundle, third box on the page, what important areas remain to be resolved? And then the last but one bullet, a government food strategy is being planned, which needs to set out clear targets for the food system's impact on health, nature and climate. This should include the role of consumers in the wider food supply chain. So specifically after net zero, noting that net zero strategy didn't include that, they repeat in assertive terms the advice they've given before. And obviously there's more detail in the earlier documents. This is refreshing, if you like, is the right word, or restating after the net zero strategy that this needs to be considered. So in one sense, whatever the Secretary of State had done before, which isn't claimed to have crossed the threshold of significant weight and cogent reasons for departing, this reset things, but has to be read against the context of what came before. But in a sense, you don't need all of that. That's our case is about engagement of the obligation. That's simply to give the court some life to what's involved in the content of it.
Right.
I think that's it, my lady. So our submission is that Section 13 was engaged in that process, and then parasitically on that, the Wyatt obligation was engaged. There's no positive claim said for both of those. As you'll have seen, the relief we seek is not by way of any quashing, because the food strategy is what the food strategy is, and rather in the same way as Mr. Justice Holgate didn't quash the net zero strategy, because it, I don't mean this in a rude sense, better than nothing. My clients don't seek to quash the food strategy. They seek declaratory relief and potentially a mandatory order, as Mr. Justice Holgate included, to produce a lawful food strategy. Just in case the court is worried, this really is the last point, unless I'm told otherwise, just in case the court's worried about the why this might matter point, you have in the bundle at page 463,
Sorry.
463 is the title page of the carbon budget delivery plan. So so Mr. Justice Holgate ordered a new Section 14 report to be produced, and this was the new Section 14 report. So this replaces the net zero strategy, so CDP post data.
Sorry, I'm for the moment adrift. This is in core bundle or
No, sorry, supplementary bundle 1, 463.
463. Yes, sorry. I apologise.
Of course, that's just the title page of the CBDP.
Yeah.
Court may know, should know, if it's relevant, that this is itself subject now to 3 legal challenges, all of which are being they're listed for hearing on a rolled-up basis. A rolled-up basis in February. They don't deal directly with the points we're concerned with here. You'd be relieved to know.
They're in the planning court now, are they?
They're in the planning court now, yes, and they're just had detailed grounds of resistance and so on, had a hearing next spring.
Right.
The only point I was going to take you to is just a very small fact on page 477, paragraph 30. As out, so it's admin court, I'm told it's admin court rather than planning court. I never quite know, there's an odd boundary, isn't there?
Well, the planning court operates as a list within the administrative.
Yes, anyway. I don't know. Paragraph 30 on page 477, as outlined, our quantified proposals and policies give us over 100% of the savings required to meet carbon budget 4.5 and 97% of the savings required to meet carbon budget 6. Now, there's an argument about whether 97% is the correct figure because there's been a changing the basis on which you calculate it argument. So there's an argument about whether this has gone backwards or forwards. I'm not concerned about that. All I'm concerned about is that 97 is less than 100. So there's still a gap. And I only show this court that because there's still work to be done. So it's not as if, let me put it a different way, it's not as if the CBDP has come along and filled all the gaps that the net zero strategy left fulfilling. The world has moved on, but there's still a gap. Unless I can assist the court further, those are our submissions.
Thank you very much, Mr. Wood. Thank you.
Rearrange the furniture for a moment.
One is fine.
Yes, Ms. Ward.
My lords, my ladies, just with an eye on the clock, I'm very happy to start now. I'm equally happy to start in an hour if that may
Are
result
there
in my
points you
submission
could
to be-
make in 10 minutes?
I suspect so. Yes,
Why not
as I say,
take?
happy to start now.
Yes, why not take 10 minutes to make some introductory points if you wish to do that, and then we'll break it around to 1 o'clock.
Grateful, my lord. My lords, my lady, there are 3 issues identified in the agreed list of issues that I hope the court has received.
Yes.
And it may be a productive use of the first few of my 10 minutes just to set out the Secretary of State's collective headline position on each of those.
Yes.
The first is, was Section 13 engaged in the development and adoption of the food strategy? And the answer on the part of the Secretaries of State, of course, is no. That Section 13, properly interpreted, requires the preparation of policies and proposals and policies looked at as a package, and the assessment process required and explained by Mr. Justice Holgate in the earlier Friends of the Earth case, what we've referred to in this litigation as the NZS case, can only sensibly be done at the whole economy level. We say also, on that ground, that even if the claimant were right in the way the case has been put this morning, as I understand it, that the food strategy itself is a proposal or policy within Section 13, and therefore Section 13 duty applies to it, that the food strategy itself is not such a proposal or policy. It contains some proposals and policies. It's referred to, or was referred to, within the net zero strategy on the basis that it was an enabling, would be in part enabling of other policies and proposals, and that's explained, and I'll show you in due course in Sarah James's witness statement in those proceedings. But the food strategy itself is not a freestanding proposal or policy. The second issue, which arises only if the Secretaries of State are not successful on that first issue, is whether in adopting the food strategy, the Secretary of State for the Environment, Food and Rural Affairs, who of course published that strategy, or in whose name that strategy was published, needed to, and this is how the issue is framed in the agreed draft, be aware of, give significant weight to, and publish cogent reasons for departing from the advice of the Committee on Climate Change in relation to diet and climate change. Again, the answer on behalf of the Secretaries of State is no. in answer, of course, to the first part of the way in which the issue is framed, of course the Secretary of State was aware, and there's clear evidence that she received advice on what the Climate Change Committee's advice was on this issue and how it was nonetheless proposed not to pursue policies in relation to dietary change, either as part of the package of policies and proposals that were ultimately accepted by the then Secretary of State for Bayes in signing off the net zero strategy, or indeed the second defendant now, the Secretary of State for Energy Security and Net Zero, in signing off the last document my learned friend showed you, the Carbon Budget Delivery Plan. So the Secretary of State for the Environment, Food and Rural Affairs was advised of what the Climate Change Committee's position was and chose not to follow it. But we don't say that she treated it as a matter attracting significant or special weight in the way that my learned friend argues for, or that there was some heightened duty to give reasons for departing from it. And in summary, on that ground, the case is that the role of the Climate Change Committee and the requirement to take account of the advice that it gives is clearly set out within the statutory scheme. And if Parliament had intended that role or those obligations to be wider or greater, it could, and we submit would, clearly have said so, as it did on a number of other occasions. The final issue then potentially is relief. The claim form, which has never been amended, seeks at paragraph 55, and this for the court's record, the court's note, is on page 144 in Core Bundle 1, seeks a declaration that the food strategy is unlawful and a mandatory order requiring the Secretary of State for the Environment, Food and Rural Affairs to publish a lawful strategy as required by Section 14 of the 2008 Act. It's not entirely clear what that refers to in the context of the Section 14 argument that the claimant was earlier pursuing, having gone by the wayside. And of course, there's no requirement under the 2008 Act to implement policies, even if they do appear in the Section 14 report taken into account as part of the Section 13 assessment. Indeed, it's expressly recognised, was expressly recognised by Mr. Justice Holgate in the NZS case, that some policies and proposals may fall out of consideration and have to be replaced by others. So it's unclear in my submission what the mandatory relief referred to in the final paragraph of the claimant skeleton is intended to attach to, particularly in circumstances where there is now a fresh Section 14 report based on a fresh Section 13 assessment by the Secretary of State for Energy Security and Net Zero, the CBDP, which you were shown, and which doesn't rely on the food strategy that you refer to it. So those are the Secretary of State's answers to the main points. It may also, in the 5 minutes before the short adjournment, be helpful to just recap briefly on what this claim is not about.
Right.
It is not a challenge to the net zero strategy. Of course, that strategy was challenged. That claim was partly successful. And the net zero strategy has itself now been superseded by the further Section 13 assessment carried out by Secretary of State for Energy Security and Net Zero, and the publication of the CBDP. It's also not a challenge, as I said, to the CBDP itself. which, as I've said, still doesn't include any proposal or policy for dietary change, and as my learned friend told you, is itself a subject of a separate judicial review challenge, not challenging the lack of any, or not challenging in terms, the lack of any reference to a food strategy or the lack of any policies on dietary change. And it's not, and this is important, this is not a challenge to the ongoing exercise, performance by the Secretary of State for Energy Security and Net Zero, which is described, and I'll take the court to it in due course, in the witness statement of Mr. Thompson of that department, at the end of his witness statement, where he sets out in outline form the steps that are taken to ensure that the ongoing Section 13 duty, which it is common ground, remains common ground between the parties, exists in the period between Section 14 reports, is complied with. The premise of this claim appears to be that something different, possibly additional to that process, is required, presumably, from the way the submissions were put this morning, every time a policy or proposal that was referred to in an existing Section 14 report is further developed or brought forward. Now, of course, I don't accept on behalf of the Secretaries of State that in any event that's what's happened here, but if it is what's happened here, it will be something that, if the claimant is right, does have very far wide-ranging implications. And my Lady Justice Andrews noted other policies within the NZS. I'm told by my learned junior on a quick count there are 183 unquantified policies. And just if I may then, in the minute remaining before the short adjournment, summarise the overall position of this government. It's that, of course, the Section 13 duty is an ongoing one. The government has taken steps to comply with it at the whole economy level. That is the proper place for it to be taken into account, where the Secretary of State for Energy Security and Net Zero can assess whether the package of proposals and policies across government, recognising, of course, that some have greater delivery risks than others, that some may, as it turns out, be more successful than expected and others less successful than expected, make that qualitative judgment that Mr. Justice Holgate referred to as to whether they are such as to enable the carbon budgets to be met. And that's the only sensible way in which this duty in our submission can operate. And not on a policy by policy, taking each of those individual policies in isolation and seeking to establish whether, without, almost by definition, having that wider overview of what everyone else in government is doing, the carbon budgets will still be enabled to be met by the overall package, because that's the purpose and the importance of the Section 13 duty. My lords, my lady, I think we are just about on 1 o'clock now, and I'll elaborate on each of those points after the short adjournment.
Thank you. Thank you, Miss Ward. Yes, well then we'll resume at 2 o'clock. Just taking stock. It does look, does it, as if there's a prospect of our completing argument today?
Subject, of course, to interventions of the bench. I wouldn't anticipate being much more than an hour and a half.
No. Right. That does look like a potential finish today anyway. Possibly. Let's see. All right, fine. We'll start again at 2 then. Thank you very much.